The question now is that clauses 1 to 4 and David Seymour's amendment stand part, and the member gets to start again.
Oh, thank you, Mr. Chair, and I wasn't tardy at all on this particular occasion. Mr. Chair, that this clause 1 of the bill is, of course, just the title clause, so I was hoping that that might allow for a slightly more wide-ranging debate, given it is only one sentence and it includes the words official information, parliamentary undersecretaries and Amendment Act. So being able to take this as one debatable question is helpful, because actually it is a very brisk bill.
Do it.
So the issues that we do have some concerns around include actually Clause 4, which varies the definition of what is a Minister of the Crown. And we heard during the committee stages some erudite observations from, for instance, Sir Grant Hammond, the President of the Law Commission, but those were in a personal capacity. Those were not made in his position as President. He was, I think, in between appointments at that stage, or the board had not authorised him to comment officially. But he was of the view that this was a device that would allow the Minister to come under the scrutiny of the OIA, the Undersecretary to come under the scrutiny of the Official Information Act. And while that might be the case, it was somewhat concerning to members, particularly on our side, that we were varying the definition of what is a Minister of the Crown. It might be only for the purposes of the OIA, but would this be a slippery slope? Would this open the door to others being considered for the purposes of the OIA to be a Minister of the Crown, even though they are clearly not ministers under the Cabinet Manual definition of what is a minister? They're not members of the Executive Council of New Zealand, and they enjoy none of the privileges, indeed protections, of ministers. For instance, Undersecretaries do not enjoy the honorific of the Honourable. They may be honourable members, but they do not have that titular honour. They also don't have the services, for instance, of VIP transport, and it might be seen as something of a luxury having access to a Crown car, but it is a very useful amenity for ministers who need to have confidential conversations, for instance, with their officials on a cell phone in the back of the car, and that they are not necessarily being overheard by taxi drivers or other people who are not cleared to the appropriate security clearance levels. So these are amenities which an Undersecretary does not enjoy, yet they will have imposed upon them the criteria of the OAA, not only with regards, obviously, to their official duties, because that already is the case. So the Undersecretary that we have in the current Parliament, Mr Seymour, is subject to the OIA insofar as he has delegated responsibilities within the education portfolio or the small business, or is it regulatory reform portfolio? But in any case, that was a concern for us, because on this side of the House, the other thing we take very seriously, as well as transparency, is also the protection of the confidentiality of constituents who might come to a Member of Parliament. So, having inherited the Westminster system, we here have Members of Parliament who also hold roles in the executive, unlike other jurisdictions, the United States, where there's that separation, complete separation between the executive and the legislature. And we were somewhat concerned, I have to confess, Mr Urafe, that it would be possible to extend this even further, or to make an argument based on the change being made here, because it is a change. We have to face up to the fact that this was not the intention, as expressed in Clause 4 of this bill. It was not the intention of the original drafters of the OIA. Certainly there was no evidence that was provided to the committee, and research was done by our Justice Ministry officials. There was no evidence whatsoever supplied to the committee that it was the intention of those who drafted the original OIA, a very forward-looking piece of legislation back in 1982, put down in the dying days of the fourth national, was it the third national government, the Muldoon National Government in 1982, many years ahead of the equivalent Freedom of Information Act in the United Kingdom jurisdiction. But when this was drafted, the Clause 4, as it is laid out now, is a change. It is a departure. It's not a correction. It's not bringing it back to what it should have been. This is an innovation. It is a clear change that we're making, so we must understand that, I believe, Mr Chair. And similarly, I think it's also necessary that we are mindful of the fact that members who are under secretaries are also members of Parliament, and we don't want this to be seen as an open door to other further innovations that could have a negative effect on, for instance, the ability of members of Parliament to conduct their constituency business with confidentiality for those who bring.
David Seymour.